What are the defences for drug driving? My name is Mohammed Zeb. I'm the director at Stuart Solicitors. Drug driving is one of the most common offences we handle, and if you've been charged or even questioned, it's important to understand what your options are. The law in this area is very strict. Legal limits for drugs are extremely low, and it doesn't take much for you to go over. You might feel completely fine, but still test above the limit, and that's enough for the police to bring a case against you. Under the Road Traffic Act 1988, there are two offences to be aware of. One is when you're found with drugs in your system above the legal limit whilst driving or in charge of a vehicle. The other being when the police say you're unfit to drive because of drugs, regardless of how much was in your system. Something important to note is that you don't need to be actually caught driving. You can be charged for just being in charge of a vehicle. So for example, if you're sitting in the driver's seat with the keys nearby, that can be enough for the police to bring a case. Now let's go through the defences that can make all the difference. One of the most effective defences is known as post-driving consumption. This applies if the drug was taken after you finish driving. So for example, you park up, go inside, and later decide to use a substance. And then the police arrive for an unrelated reason and test you. The result might come back positive, but that doesn't prove that you're over the limit at the time of driving. To support this defense, we usually instruct a toxicologist. They look at your age, weight, height, and the timing of both the drug consumption and the blood sample. If our report supports your version of events, we present that evidence at court. We may also use texts, call logs, witness statements, or CCTV to confirm the timeline and back up your story. Another line of defense comes into play if the police haven't followed procedure. There are clear rules under the Police and Criminal Evidence Act, also known as PACE, that officers must stick to. For example, if they didn't caution you properly, or took too long to carry out the test, or failed to explain your rights, that could seriously affect your case. To highlight what's happened, we look closely at what's happened during and after your arrest, including custody records, body-worn footage, dash cam, and any available CCTV from the location. When something doesn't add up, we raise it with the court and challenge the reliability of the evidence. If you've enjoyed the video so far, please make sure to subscribe. You may also have a defense if there's no clear evidence that you were driving or even in control of the car. This happens more often than people expect. For example, somebody may be asleep in the back seat or just sitting in the car with no intention of driving, but still end up with a charge. When that happens, we break down the details of the situation. Where was the keys? Were you in the driver's seat? Was the engine running? What was the nature of the police intervention? If the prosecution can't prove that you were intending to drive, then they don't have a case. Another situation we deal with is when the drug in your system was prescribed by your doctor. If you've taken a drug that was legally prescribed to you and you followed your doctor's instructions, then that in itself is a defense, as long as you weren't impaired at the time. To back this up, we request your GP records and your prescription history. If necessary, we ask a medical expert to review the case and confirm that your use of the drug was consistent with what was prescribed. It also helps if we can show that your driving was normal, which comes from dashcam footage and witness statements. We also closely examine how your blood or urine sample was handled. These tests have to follow strict procedures, and if something goes wrong, like the sample wasn't stored correctly or tested within the time frame, it can call the whole result into question. To check for this, we request the lab records and the chain of custody documents and ask our own expert to review them. And if anything looks off, we challenge the evidence even before it goes to trial. There's also what we call the metabolism defense. Just because you tested over the limit doesn't mean you were over the limit at the time of driving. Everybody processes substances differently. The level in your system could have been legal at the time you were behind the wheel and only got up afterwards. We use toxicology experts to help with this kind of defense. They can assess how your body would likely have metabolized the drug and the level you would have had in your system at the time of driving. Sometimes we come across cases where somebody was spiked without their knowledge. You might have been out socially and had something slipped into your drink and later tested positive without ever knowingly taking anything. When that's the case, we put together a timeline of events and speak to anybody who can support your version of what's happened. If available, we use CCTV and expert analysis to show that the drug in your system wasn't taken intentionally. That lack of intent is key to your defense. As you can see, drug driving cases are complex, but they're very much defendable. Whether it's challenging how the police handled your arrest, bringing in expert evidence, or simply showing the timing doesn't add up, there are many ways to fight the case. At Stuart Solicitors, we've defended hundreds of these types of cases and know exactly what to look for. If you've been accused of drug driving or under investigation, don't wait and hope it'll go away. Get in touch with us for a free initial consultation and let us help you protect your future. Subscribe for more.